Yes. But yes, I do need to go over to.
Trey, how was Japan?
Thank God, mine are the same.
Back in the swing of things.
But yeah,
Your dad was here. We said we're gonna see how long the glow lasts.
that's why I don't do. Because it's just so much easier to do this. And my husband, he's so big. He still does the contest. I can't see. I can't see it. I'm like, stop using this. Yeah. Because you're not. Wow. That is scary. So I had the things that we don't think.
I know. And my son just finished.
My turn. We still have. Oh, I'm shocked.
My oldest.
I don't. And then we got.
Norma, can you call attorney Melissa Christian and see if she's in the building, if she can come over?
Yes.
Thank you.
Oh, yes, ma'am, I'm sorry. Thank you.
All right, I'm gonna call the docket. I know they're in custody. Melissa Paez, Lennon Cortez, David Crenshaw, Dominic Smith, Vincent Munoz. All right, thank you. All right, and that's all we have on the docket today.
Yeah, I heard about it. What I see about,
Hello, I'm doing great. How's everything going?
Great.
So we will see if we're in trial today. Yeah. So usually they'll have another chance to talk and see if the state has made a different offer or not. Yeah.
Yes, and you're repeating, you have to.
Sure.
This is your.
Okay,
Thank you.
you're welcome.
I can't see the last of the numbers. No, it's not, but it does say what day is it.
Norma.
No, you were this as not to for her. Okay.
But you want your business card?
You can put yours so that they can email you. All right, thank you. Yeah.
It's 26.
26.
26.
Oh, they need the wrong form. Oh, you know why? Because the copies in the back had 187. Oh.
But yeah, so the cases that we're supposed to go on trial today, if they decide to go, one is a third-degree felony and one is a state jail felony. So third-degree felonies, the range of punishment for that is anywhere from 2 to 10 years in prison or potentially probation. So in jury trials, what ends up happening is in Texas, there are two phases to a trial. People call it the innocence phase, but phase one is really not the innocence phase. Phase one is, did the state prove their case or not? And did they prove it beyond a reasonable doubt? So before anyone goes to trial, they have to make a decision. They call it an election of punishment. If you were found guilty, do you want the judge to decide punishment or do you want the jury to decide punishment? So some cases you have a defendant is not eligible for probation from the court if they go to a jury trial. They're only eligible from a jury. Now, if it's proven that you've been to prison before, just 1 second, sorry. Some cases you're not eligible for probation going to a jury. It just really depends on what the case is. For example, if you've gone to, well, actually any case that you've gone to prison before, because you have to take an oath and they have a form. And on the form, when you fill it out and you're applying for probation, you're swearing under oath that you've never been convicted of a felony in this state, this county, or anywhere else in all of the United States. And usually and I'm sure it applies if you were convicted in a felony in another country. We just never had that before. But with regards to convictions out of state, out of country, in the code book here, they actually have how you judge that, whether it's a felony or not. That's why I say it depends, because some places their felonies are different than here. So maybe something that would be a felony here is not a felony there, and something that's a felony there would not be a felony here. So you just look in the code and see how that's to be treated. I've had that happen as a defense attorney when I was defending somebody maybe 5 times, where they had something that was out of state, that wasn't a felony, and the state was trying to say it was a felony here. So we had a big, debate about that. And then once they make a decision on whether or not it is, they're going to the judge or jury for punishment, then the way that the trial goes, if there are pretrial motions, they're held pretrial. That's why they call pretrial motions. Now, sometimes people will run their motions with trial. Usually that happens if there's a motion and it's substantive. So what that means is there are going to be witnesses that are going to be called. Normally on your motion in limites where people say, I just don't want this brought up before a jury, usually you don't need any witnesses for that. Because as a judge, I never know if it should be brought up or not until I know what the case is about. And a lot of times people think I know what the case or know some facts in the case. I really don't know any facts in the case unless they've had a motion before me, like a motion to suppress or something. Then I get to hear a little bit what the case is about. So for this case that we may be going to trial on, all I know what the charge is. And once the clerks give me the indictment, I'll be able to see if is this habitual or not a habitual, or is it a repeater or not a repeater, because that has determination on whether or not they're eligible from a jury. Eligible to receive probation from a jury. So once all the pretrial motions are out of the way, if they have any, the next thing that happens is they do what's called voir dire. People say, Stephanie, you're in Texas, it's voir dire, but it's voir dire, that's how it's pronounced. And it's basically jury selection. People are brought up and either side gets to ask whatever questions they want to ask. And people are always asking me, well, why are you only giving 20 minutes for this or 30 minutes for selection? That's just based on my experience of how long jury selection should take from each side. However, if somebody's asking a question and they're asking something that's new, that's relevant, I'll allow them to ask that and extend the time. But if everybody's just saying the same thing, and that's how you preserve error. If a judge has given you, let's say a judge gives you 20 minutes to speak to a jury, and you're using your time wisely and you're talking to the jury and you have important questions that need to be asked. And the judge is like, I'm going to cut you off because we all agreed to 20 minutes. Well, they can object to that. And then I would make a decision on whether is this something new or is everybody asking the same thing over and over. So once they do jury selection, what ends up happening, every court is completely different on how they handle jury selection. Some courts will do specific, general. So I'm sorry, general, and specific. So you have what's called general voir dire. General voir dire is where you just ask general questions, like how do people feel about something? Like, for example, the Constitution declares that anyone who's accused of crime has a right to remain silent. Is everyone in agreement with that, right? So you ask that general question and maybe somebody will raise their hand and say, I don't agree with that, So then once you finish with all your general questions, then you come back and do specific. All right. And so what is specific? That juror who raised their hand saying, I don't agree with that. You start asking them specific questions like, okay, you say you don't agree with this. Why? What's going on? So each side, and of course there are exceptions to every rule, but each side in felony court, they receive 10 strikes. 10 strikes for whatever you want. The only thing it can't be discrimination. You can't say, I don't want any black people on the jury. Let me strike all black people. Can't do that. So, but other than that, you can strike them for whatever reasons. Like, I don't like his tie. I don't like the way he was looking at me. And you can just strike them. No. This is still during jury selection. Now, mind you, if there were black people on the jury, and then the defense attorney sees that all the black people have been struck, and either one can challenge and say, hey, they're just striking all the black people. Like the state can do that, the defense can do that. So if they strike, then, the state of defense will have a Batson challenge and say, hey, they struck all the black people. And then all you have to do as a prosecutor, as a defense attorney, is come up with a non-discriminatory reason why you would do that. Like, for example, you would say, well, John Doe said he didn't like engineers. My client is an engineer. And just go through that. You'd be shocked. Sometimes people can't come up with anything. And they're like, oh, because they're always shocked when they get that, because they're thinking, oh my gosh, they're saying I don't like black people. So they each get 10 strikes, and then they have what's called strikes for cause. And strikes for cause, you have as many of those as there are causes. And the strikes for cause are, like I say, people who won't follow the law, people who can't consider the full range of punishment, that type of thing. So once they finish with that, the strikes are turned into the clerk goes over it, and then from whoever's left of all those strikes, those are the people who appear on the jury. And some judges will do for jury selection, some judges will give an introductory. I try to give an introductory about the principles of jury trial and everything, and the reason in the law. And the reason why I do that, so that both parties will have more time to get into what they really need to get into about voir dire. Sometimes they take use of that, sometimes they don't. But there are some judges who say, okay, y'all have 30 minutes per side for jury selection, and the judges don't say anything, and they just let them go at it. But I do it the way I do it because of what I learned from being the defense attorney and prosecutor, and what I like. So, and what I think helps both sides. So then once a jury is selected, then I swear them in, and basically I swear them in differently from downstairs. Downstairs, when they're being qualified, they're just being sworn in that, hey, you're going to answer the questions that are asked of you, and you're going to be truthful about it. But when you're on a jury trial, it's a different swearing in. It's like you're going to listen to all the evidence, and you're going to base your decision on whether the person is guilty or not guilty, if you can, based upon the evidence that's presented to you in the law. So once all the jurors are sworn in, then the state stands up and the state reads the indictment. And it starts buying through the name of the grand jury, blah, blah, blah. And then it gets to the offense. And then the defendant will stand up and he'll either plead guilty, not guilty, or no contest. Sometimes it's guilty because they just want to go to a jury for punishment. I've seen that in my career, probably like about 10 times where someone does that. But usually it's not guilty. So with regards to the indictments, the state is not allowed to read any portion of the indictment that has enhancements in it. The only time they're allowed to do it if it's for jurisdictional purposes. For example, you can only be in felony court on a DWIs if it's a DWI third, or either, driving with the child in the vehicle. But for this example, I'm just going with DWI thirds. So they will have to read the other two DWIs in order to get there. And it's the same thing with assault family second. So they'll have to read, hey, this is assault family second, otherwise we can't be here. But other than those situations where it's jurisdictional, they're not allowed to read the enhancement portion.
It's also like the first, or is it just,
No.
it's first?
Just 1 second.
Excuse me.
Give me a copy of an indictment. Does anybody have an indictment? So when they and I'm going to have them show you an indictment. When you have an indictment doesn't have facts in it per se. It just has the allegations of the charge. Like, for example, for a murder case, it'll have that it happened in Bear County on the indictment. It'll have a date that it happened on or about the date. It'll have the defendant's name. It'll have the deceased person's name, and it'll have the how. How did they die? It's by, shooting with a firearm, by stabbing, whatever it may be. That's all that's in there. And that is the indictment is supposed to be enough in there to put the defendant on notice what they're being charged with. Because if they just say, hey, you're charged with murder, and it's like, okay, who am I charged with murdering? What's going on? Hey, Charles. Yes.
Are we on? Yeah.
Yes, ma'am. And so that's all the indictment usually says. It does not put facts, it doesn't say witnesses' names or any of that. So once the state reads the indictment and the defendant says, oh, thank you. Once they say guilty or not guilty, then we proceed. Yeah. So this is an example of an indictment. So for example, this indictment is unlawful possession of a firearm by a felon. So you see the date. And then this, in order to be a possession by a felon, you have to have a felony conviction. So they have to put that in there. Normally, if, say for instance, it's a drug case, possession 1 to 4 grams, that's a felony, right? Now, and the range of punishment is 2 to 10. Now, if there's another case where the person went to prison or has a prior conviction and the state wants to make that range of punishment 2 to 20, they can't read the other thing. That will only come in and punish. And then, once the state reads the indictment and the person says not guilty, then the next thing that happens is the state gives an opening statement. And they will tell, basically, I tell my students, it's similar to a book, right? And you open it up and you read the jacket to see what the book is about. That's their opening statement. They're telling them what this case is about. Now, mind you, they're not allowed to argue. So that's why you'll hear people say, we expect the evidence to show. That's how we were taught in law school. But as you start doing this a lot, depending on if everybody is contentious or not, they will allow the state to get up and say, on July 24th, 2024, this is what happened. And they just go through their thing. Now, if they're being picky about everything, sometimes you'll hear objections, like objection, Your Honor, argument. And then after the state does their opening statement, then the defense will get a chance to do an opening statement. The defense can do their opening statement right then and there, or they can say, Your Honor, we will deliver our opening statement after the state finishes their case in chief. Sometimes as a defense attorney, you don't have an opening statement to give. It's hard because it's like, it's on video. Mother Teresa is coming in to testify. The accused mom is coming in to testify against him. So sometimes you don't have anything. And what I can tell you, when I was a defense attorney, you would go to the CLEs and they're like, you should always make an opening statement. That's easy to say. Sometimes you don't, and there's different schools of thoughts, because sometimes our professor would say, it's not good for your opening statement to be the state won't be able to prove their case, because that's sort of saying, oh yeah, my client did it, but the state can't prove it. So you just have to figure out how you're going to do. And that's why people will discuss sometimes with defense each other about, what do you think about this? How do you think I should approach this? So after all of that is done, then the next thing to do is the state calls their witnesses. And before every witness testifies, they have to be sworn in. And the state's witnesses are supposed to be able to prove up or give testimony on everything that's in this. Otherwise, they're not relevant. Why are they here? And then sometimes people want to testify to hearsay, and people object to hearsay. There are some exceptions to that and some things that are not hearsay. When people forget reasons why it's not hearsay, usually people will say, well, I'm not offering it for the truth of the matter asserted. And then a good defense attorney will say, well, what are you offering it for? Because then if everybody starts, I'm not offering it for the truth of the matter asserted, then every witness, I'm not offering it for the, what are we offering it for? So after the state finishes calling all their witnesses, so they'll do direct examination. The defense can cross-examine or not cross-examine. They can say no questions. And then you can do redirect where you come back because you want to clean up something that's said, or recross. And usually when you do redirect and recross, it's supposed to be narrowing it down. It's not just opening up all wide again, but that tends to happen. So then the state will rest after they feel like they've called enough witnesses to prove their case. And then at that time, if the defense didn't make a opening statement, they can make an opening statement, or they can go right into witnesses, or they can say, we have no witnesses. And also after the state finishes with their evidence, they can ask for a directed verdict saying, hey, they didn't prove their case. So if the defense decides to put on witnesses, same thing, they'll be sworn in. The defense will then be on direct examination, which means they have to ask open-ended questions. Introductory questions, you can ask leading questions because it has nothing to do with anything and you're just sort of setting the stage. And then state can question their witnesses, then ultimately the defense will rest. And then you can go back to the state to see if they have any witnesses they want to call to rebut something that happened, what the defense put on. And then ultimately both sides will rest and close. Then the jury will take a break and we'll do the jury charge. They call it the charge of the court, but it's just a document that has the law the jury should follow. And then at the end, it had verdict forms for guilty, not guilty. So both parties will get a chance to review that. Once they review that, I'll see if they have any objections. If they don't have any objections to the charge, that's the charge. And then both parties will let me know how much time they're asking for closing arguments. And then once they do their closing arguments, nobody can talk to the jurors anymore. And I send the charge back, and then they have sheets of paper, and any question they have relative to the case, they have to put it in writing. And so if they have a question like, oh, was this person wearing a blue shirt or green shirt? Then we have to answer that. But if they say things like, we want somebody's entire testimony, you're not allowed to get entire testimony. That's why I know jurors sometimes gets frustrated because we'll send back answers to their question. You have all the evidence, continue your deliberation. They're like, no, we want this person's testimony. Or either they always ask for the police reports, which are not admitted into evidence and they can't get them, but we want the police reports. So, and then ultimately, if they can come to a verdict, they come to a verdict. If they say, oh, we're not going to come to a verdict, then they want them to continue deliberating, or they want to do what's the Allen charge. And the Allen charge, it usually tells the jurors, look, other jurors, if we call up another jury, they're going to have the same questions you have and the same difficulty you have. So continue your deliberation. But once they use the words, we are hopelessly deadlocked, then it's usually granted. But if they come back with the verdict, and if they were to find someone guilty, if the defendant said he want to go to the court for punishment, then the judge will decide punishment. But if he says he wants to go to the jury for punishment, then the jury will decide it. And usually the punishment phase, either to the jury or to the court, is the same. People present whatever evidence they want to present. And then if they come to a decision on punishment, they come to a decision. If they don't come to a decision on the punishment and they're hopelessly deadlocked, what ends up happening is, it's signed mistrial, but it's mistrial as to punishment. And the only thing the defense gets to do is they get to come back and try punishment all over again. When I first started practicing, if you got a mistrial on punishment, you're like, victory. And the reason why you would say that is because you get to try the entire case over. But they changed the law and now you don't. Now, of course, if you come into the court for punishment, there should not be a mistrial because you should be able to figure out punishment. And then after that, if somebody's found not guilty, the attorney can file for expunction, which means erasing every document. If they are found guilty, they can do a notice of appeal. And either the attorney who tried the case will be the attorney for the appeal, or either someone will be appointed. And then however long it takes them to figure out the answer. And then if they rule against them, then the person can file a motion for a petition for discretionary review. That'll be up there, and then they can appeal from there if they want. So that's what happens. But usually you have sometimes people enter plea bargaining agreements, the plea is accepted, and then they file a motion to appeal, which you waive your right to appeal. So ultimately the fourth court will see that, hey, this was a plea. It's not going to happen. But if you had filed any pretrial motions and then you entered a plea, and if those pretrial motions have been ruled upon, you can appeal that. And appeal the pretrial motion ruling.
That's, it's an MTR and a new case.
Okay.
Okay, do you need me to sign the book or?
All right, Norma. So according to this, sure. But yeah, so that's what we do. And then right now, I'll show you the plea paperwork once we complete the paperwork. So. So, yeah, so that's what we do. Yeah, it is. And you know, it's so funny whenever I'm in the community, because they'll ask me, well, what's the biggest thing? And I told them, Judge Priest always said the biggest thing is to have patience and to really have, to forget things that people have told you. Because sometimes people are like, hey, that person just said the same thing that this person said. How do you just not go, bam? I've heard this 1,000 times. And my thing is, I'm paid to listen. Like a lot of this job is listening and also knowing the law, right? And I always tell everybody, I don't claim to know everything. So if you have some law and you want me to hear it, I am here to hear it. So, but it happens. So that's the big thing.
Thank you.
It's true.
Okay. I'll try it once.
Takes.
Your hopes after one.
Go with the board. Okay.
Okay, sure. And you can use it in the back. Yeah, if you go back there.
Yes, I do.
You're welcome. Yes.
We're gonna be taking a plea on a case and I'm handling an MTR. And I've already shown that to the DA, so I thought I'd give that to you ahead of time.
All right. Do they have any objections to my reviewing it?
No,
That to you. Yes, 2 cases, and then there's 3 dismissals. Do I need to sign in sheet? Correct, thank you.
And here's this. So is it really gonna snow?
No,
it's gonna sleet.
It's gonna make the streets thick. Nice.
Is the courthouse gonna be shut down?
We close on weekends.
Yeah.
When is it?
this weekend.
Friday. Yeah. Right back.
And Charles, when you see Cornelius, he said he don't understand how that pass was wrong with Miami. He's like, I don't understand. I'm like, I don't either. But sometimes it's a team's year, you know?
Definitely, it was their year.
Yeah, I remember when the Saints won the Super Bowl. It was their year because they come back at halftime and they do an onside kick. Who does an onside kick at, coming back from halftime? They did. And then after that,
Great things happen.
yeah.
Go back down. Judge, you don't need no speech there, have to go back down.
They're not going back down.
They have to go, they need to back down.
Who told them to go back down?
Wednesday.
So sad that they have to go back down. Okay,
I'll have Mr. Smith.
all right, thank you.
Which one? Good one? Philip?
All right, and then somebody said that you should binge watch this show. You remember the actor who played in ER with George Clooney? Is his name? He also played in The Librarians.
For the pit?
Yes.
Oh, I love it. I love it.
Okay, so I'm gonna have to watch that.
Yes.
It's very good.
All right. And the guy said it's great because the 15 hours are just 15 hours in their day.
Yes.
15-hour shift, yeah. Every episode's a different hour of the shift.
Yes.
Oh my gosh,
24.
I guess sort of.
So,
No, I haven't. So there's a book?
there's a, but I watched the series before reading books, but it was.
Okay, I'm gonna watch it because you guys know I'm in the twilight of my life, so don't have me watching stuff.
No, it's good. It's series, so it's not that big of a time.
Okay.
Is it like 8 episodes? Is it episodes? They all watched it. Yeah. See,
Oh.
we all recommend. Yes, absolutely. I was trying to convince her that it's like a Frida McFadden type of twist, but it really does.
Well, you know what I've been.
Sean Burnko or whatever, I was watching it just.
Well, you know what I binge watched and I highly recommend on Netflix, Haunted Hotel. It's a cartoon. Oh, it is very good. It's about this lady and her 2 children who stay in this hotel that's haunted. And one of the people who's a ghost there is her brother. And so he willed her that hotel in his will. It's hilarious. Well, I mean, they can all see him. Yes. And so it's hilarious.
And Judge, you haven't seen K-pop Demon Hunters?
Okay, I'm working on that.
I fall asleep every time I watch it.
See,
It's cute.
she says she falls asleep.
It made #1, the song, the music. The
Mhm.
songs are top.
Is it better than the original Transformers?
Yes.
Oh, see now. All right, who's here on Dominic Smith?
President Trotter.
Court is calling 2025 CR 014065, 2025 CR 014136, State versus Dominic Smith. Can I have parties announced?
Repaying for the state of Texas.
Roger Pettis for Dominic Smith, Your Honor.
And are you Mr. Smith?
Yes.
All right, counsel, have you received all discovery in each of these cause numbers and did you review it with your client?
Yes, Your Honor.
And each cause number, the court will find that the state is in compliance with discovery. Mr. Smith, in each cause number, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, in each cause number, do you waive the reading of the indictment?
We do, Your Honor.
State, in the cause number ending in 6-5, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
And in the cause number ending in 3-6, are you proceeding on the indictment as presented?
We are not, Your Honor. We are proceeding on count 3. And on that one, we'll waive counts 1 and 2.
No objections, Your Honor.
And Mr. Smith, in each cause number, did you review the application for deferred or community supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
In each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? And cause number 2025 CR 014065, you're charged with violation bond or protective order 2 times or more within 12 months. And in cause number 2025 CR 014136, you're charged with stalking. These are 3rd-degree felonies. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand? In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. By entering this plea, you're giving up those rights. That you intend to give up those rights and enter into pleas in each of these cause numbers. In each cause number, did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you to 10 years in prison in each cause number and up to $10,000 fine. Did you understand? Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Smith, in either of these cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering into these pleas, you will be deported, denied naturalization, and re-entry. Did you understand? In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes.
In cause number ending in 6-5, according to the plea, punishment is to be assessed at 6 years in the prison. There's a $1,500 fine. State is opposed to your applications. This will run concurrent with the case number ending in.
Now that you said, I think I need to fix that.
All right. Any objection to the court just correcting that?
Yes.
All right. No problem. This is the run concurrent with 2025 CR 014136 and 2025 CC 014639. The state is taking in consideration 2025 AL 001293 and 2025 AL 002994. And there's to be restitution, if any. And there's to in the cause number ending in 36. The state is proceeding on count 3. Punishment is to be assessed at 6 years in the prison. There's a $1,500 fine. State is opposed to your applications. This will run concurrent with 2025 CR 014065 and 2025 CC 014639. They're taking in consideration 2025 AL 001293, 2025 AL 002994. Restitution, if any, and the same no contact orders. Did you understand that to be your plea in each of these cause numbers? Defense is at the plea?
It is, Your Honor.
State is at the plea. Did you review the waiver of appeal paragraph with your attorney in each of these cause numbers? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
There have not been, no.
Then in cause number 2025 CR 014065, how do you plead? Guilty, not guilty, or no contest?
No contest.
To count 3 in cause number 2025 CR 014136, how do you plead? Guilty, not guilty, or no contest?
No.
State any evidence.
Mr. Chairman, with regard to both cases, state will offer into evidence if exhibit 1 of the fact.
No objections, Your Honor.
All right, and state, have you spoken with the complainants? All right, thank you. State, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments, and the court will review the same. Right. In each cause number at the review and states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt in each cause number as you apply for deferred adjudication. All right. Counsel, if he wants a full PSI, it's going to be about 8 to 12 weeks. If he would like to come back sooner, if you waive PSI, what will end up happening is I'll give you a chance to have whatever witnesses or whoever you want brought in to testify or whatever evidence you want to present to the court. But otherwise, it'll be 8 to 12 weeks for a PSI and TAP evaluation.
Mr. Smith is very motivated to get out, so the sooner the better. And yes, will there be any, you'll just have some confirmation of his record or anything from the PSI?
The state will probably most likely give me any type of criminal history. But what I can tell you all from reading the stipulated evidence, do you think he needs a MIC evaluation at least?
He's a veteran, spent 4 years in the military.
Mhm.
And on a particular date, I don't have the date in front of me, Your Honor, he had a motorcycle accident, which his case is pending.
Mhm.
So there was a TBI involved. So I have a volume 1 of his medical that I was going to try to succinctly place before Your Honor.
Okay.
And the better news is he has grandparents who are here present. They've been very active through the case this entire time, very supportive. If we were to be granted probation, he would reside there immediately. The same day or the following day, he's going to be in with the doctor to get the appropriate medication to assist his situation. And will have the resources, we think, based on the accident resources that we think we're going to get as a result of the traumatic brain injury accident. And so none of these things are going to occur in the future. He's going to be a stable resident. He's going to receive the right medication. He's going to have just a new outlook. He's been, very remorseful about this whole entire situation and what he did. And, he realizes the situation he got himself in. He spent almost a year in custody and he's just very motivated to get out.
Okay. So, I mean, that's information you may want to let the state know. So do you want a MIC evaluation? If there's a MIC evaluation done, how long would that still be? 8 to 12 weeks?
Judge, I could probably get it done in 6 weeks.
Give me one quick second.
Sure.
Regarding a big evaluation, we've already, in the volumes of information I have, there's already been an evaluation. That'll be some of the testimony that we'll provide to the court. So we could have just a shorter time frame, maybe a few weeks before we come back,
How long would you request
in terms of
time for us to come back?
3 weeks or so would be fine, and then I will get a packet ready for the court and the DA for that day.
All right.
And we probably need about 15 minutes in terms of court time with the grandparents to testify.
Is veterans treatment for an option?
We can do yes, I think we should probably see about Veterans Treatment Court.
I just text to see if someone's coming up.
Okay.
Okay. All right, Ms. Ferguson, I need a date. Well, you know what? Let's not do a date yet. Let's confer. You confer with Veterans Treatment Court.
Okay.
Just have a seat and then we'll come back and I'll give you a date, but I'll note for the record that you're waiving PSI and TAP evaluation.
Thank you.
All right, so just have a seat and they'll be up here. Anyone else ready? Vincent Munoz. Hello.
Good morning, Your Honor.
Good morning. Sorry, I'm just marking a couple of things off. Are there any applications?
Well, on the
For
burglary is being reduced to a misdemeanor.
Okay,
On the MTR, we're going to open on the MTR.
okay. All right, then we'll start with the burglary. The court is calling 2025 CR 0149998 State versus Vincent Munoz. Could I have parties announced for the record for the state?
David A. Garcia, attorney for Vincent Munoz, judge.
And are you Mr. Munoz?
Yeah.
Counsel, in that cause number, have you received all discovery? Did you review it with your client?
I have and we have.
Court will find that the state is in compliance with discovery. Mr. Munoz, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, judge.
State, are you proceeding on the indictment as presented?
Proceeding on Western.
Any
No
objection?
objection.
Did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, the state is proceeding on the lesser included offense of criminal trespass as a Class B misdemeanor. The range of punishment is up to 180 days in the Bexar County Jail and up to $2,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses, and the state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do and he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is.
Mr. Munoz, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Did you understand if you're not a U.S. citizen, by entering this plea, you may be deported, denied naturalization, and reentry?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense of criminal trespass. Punishment is to be assessed at 114 days in the Bexar County Jail. There's an $800 fine and no applications. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Sure.
Counsel, there be any such motions?
No, Judge.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
We've reviewed states one and all attachments, Your Honor. We have no objections.
All right. Mr. Munoz, did you review the document entitled waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses in statement call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, regarding the misdemeanor that he's pled to, we're just asking that you go along with the plea bargain and that it run concurrent with whatever ends up happening on his SDR.
All right, this is what the court will do. Court will follow your agreement. The court will find you guilty of the lesser included offense of criminal trespass. Court will sentence you to 114 days in the Bexar County Jail, give you credit for any time served. There's an $800 fine, time and money to run concurrently. With regards to sentencing,
No, Judge.
oh, and I'm so sorry, and this will run concurrently with all right, 2024 CR 1361.
Yes.
All right, on that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
We're moving on to cause number 2024 CR 2024 CR 1361. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Vincent Ambrose Munoz who was placed on deferred adjudication in 2024 CR 1361 for the offense of abandoning a child criminal negligence on April 9, 2024, for a period of 4 years. Is that you?
Yes, Your Honor.
All right, state.
Violation of condition or in Texas, the Annette, Vincent, Amherst, Munoz did then and there fail to report to the supervision officer as directed for the month of June 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
And abandoned.
No objections.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility
Yes.
and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, Your Honor.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There's not just something that you it's motion and revoke his community supervision and sentence him to 2 years at the state jail facility.
All right, in defense, what are you requesting?
Judge, we went open so that my client would have an opportunity, one, to be reinstated, and if in the alternative, to see if you could be a little bit more lenient than the state. He faces 2 years state jail. Clearly, he made a lot of mistakes. Probation's recommending revocation. The
Mhm.
state's recommending revocation. He just pled to a burglary that was reduced down to a criminal mischief. He made a lot of bad choices. He was close to finishing one of his classes, and then the burglary arrest occurred. Doesn't excuse what happened. He made a bad mistake to go someplace with who's now the mother of his child, mother of his child to be. She's due in 4 months,
She's due on June.
in June,
5 months.
5 months. He
What
should,
did you do when that criminal trespass occurred?
No, we found out she was pregnant when she was incarcerated.
Okay,
she got arrested with him
Ah.
at that instance. She was, our understanding was the main aggressor at the door, but the state reduced her case to a criminal mischief, and they did so with my client. He understands he made that mistake. He should have never been there. They went there to get the clothing for Kimberly's children, not his child, correct? But nonetheless, it was a bad mistake to go. He understands that. That's why he took this plea. He understands he had been making a lot of mistakes on his probation, but while he's been sitting in jail, Judge, he's tried to turn his life around. You saw the certificate of completion for the child class, the fact that he's been going to meetings. He's really been trying to change things for himself, even though he understands he made a mistake and it's a grievous mistake. He's throwing himself on the mercy of the court, hoping, one, you reinstate him. He's got a job waiting for him. He's got this baby coming in 5 months. And if not, he understands, but he's hoping you give him a more lenient sentence to 6 months in state jail or a year, so that he can do his time and get back to his job and help raise his child and move on in his life.
so what has he done on probation? Has he done anything?
I did,
Want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Vincent Munoz.
All right, what have you done on probation?
I completed my first class with the driver safety course. I was right before catching this charge. I was one class away from finishing my parenting class. Then after that, I was going to start my AA. I was showing up to my meetings and everything, but I didn't end up showing to my drug testing because money was tight, but also I didn't have a reliable transportation. But my sister has an extra car that she paid off and got her new car, so she told me that hopefully willingly that she has another car for me so I can have reliable transportation to show up to my meetings, drug testing, my job and classes or anything that I need to do to be responsible for myself.
All right, any questions, state?
Or guest registry.
No.
Okay, Mr. Munoz, so when you were placed on probation, you provided the probation office with an address of 15800 Chase Hill Boulevard. And then it was apartment 310. Do you recall that?
Yes.
Okay, whose apartment was that?
That was my ex-stepfather's.
Okay. And so one condition that you had for your probation, I guess it was amended later on, was that you were supposed to reside with your mother at 2503 Jackson Keller Road. Do you recall that?
Yes,
Okay, and so at the time that you were arrested for this charge, that you just pled to, the,
Criminal trespass.
um, you were not residing with your mom, correct?
Yes, ma'am. It's because they ended up splitting up. My mom and my ex-stepdad.
Okay, so if I'm understanding correctly, that address at Chase Hill Boulevard, so your mom and your stepdad were living together there, is that correct?
No, Chase Hill Boulevard, that was
Your stepdad's address.
no, the stepdad address was 2503 Jackson Keller and Chase Boulevard. I was staying with my partner's friend. She helped us roommate there, but I had ended up telling my probation officers because I had nowhere to go. That was my last option. Cause I was, throughout this time, I was back and forth to hotels and motels.
Okay, and so you were not residing with your mom, you were residing with Kimberly and then the friend that was helping you all.
Yes, ma'am.
Is that fair to say?
Yes, ma'am.
Okay, and then regarding your urinalysis, you were instructed to provide samples multiple times. If we're looking here. 9 times, you recall that?
Yes, ma'am.
Okay, and you didn't show up to provide UA 9 times.
Yeah, it was like I didn't really have too much reliable transportation, and it was just where I was staying at, my mom and people, it just didn't match their time schedules, what they were working, and I was trying my best, and every money that I did had, it was either helping out on rent or going on.
Okay, so help me understand this correctly, because you're saying that you have reliable transportation to go provide your analysis, correct? However, on the day that you were arrested for criminal trespass, you and Kimberly were in possession of a Dodge Durango, correct?
Yes,
And you all drove over to Dionisa's address, correct? So you have reliable transportation to go commit other crimes, but not to comply with your probation, is that correct?
yes, but I had just asked my sister if I could pick up her stuff. That was that extra car that she was that I was speaking of.
But she couldn't provide you help to comply with probation?
It was, she had just got a new car about the beginning of September, so at the time when I did ask her, she was like, she didn't really want to let me use it, but she was just like, I just needed to get his clothes.
And then you stated that you completed the aggressive driving course, is that correct?
Yes, ma'am.
And probation was provided with a copy of that,
Yes, ma'am.
okay, but you were also ordered to do your sober support meetings and parenting class, and the parenting class is something that you completed while you were in custody after being arrested, is that correct?
Yes, ma'am.
Okay. And then the one time that you did show up to UA in July of 2025, you were positive for marijuana, correct? And so you're here asking this court to be lenient on you, is that correct?
Yep.
But you have not provided any evidence to this court that 1, you deserve leniency, or 2, that you ever intended to comply with probation. You would agree with me, right?
Yes, ma'am.
Okay. You have to learn this.
Any further questions?
Just a few, Judge. Vincent, you sort of glommed over the fact that you didn't show up to these UA tests because of transportation, correct? Was financial and the financial aspect also a reason you didn't show up?
Yes.
Explain that to the judge.
A lot of money that I had saved up was going towards hotels, and I didn't really have nowhere to go, so that was mainly where my money was going at, and I didn't really have a car, so I would always use Uber to get food or something like that.
And you're not trying to tell the judge that you have an excuse for everything, correct?
No, I take full accountability for my.
So you understand you did very poorly on this probation,
Yes.
but you're trying to explain why. It was, a lot of it was financial. And so you would show up to meet with your probation officer, they would tell you to show up for a urinalysis test. And you told them you didn't have the money, correct?
Yes,
Because it costs every time you show up to give a urine test.
yes,
And so that's, and you pled true to not showing up because you didn't, right?
yes,
So even though you messed up on your probation, you were trying, correct?
yes,
And you almost finished that parenting class through probation, didn't you?
yes, I was 1 class away.
Okay, and then you got arrested because of another bad decision, right?
Yes, sir.
But while in jail, you did complete the parenting class.
Yes, sir, and then I started my AA classes as well.
If the judge grants you this opportunity to stay on probation, can you promise her, in spite of financial reasons, you'll make every meeting, you'll show up and you'll be clean?
I promise, and I do stand on that, as well as like as I told her, I have reliable transportation. I talked to my grandma here a lot too. She put about 300 aside for me for my drug test. Kimberly as well, she has a few checks that she had saved up while being in here. She told me as well she could help me with my restitution fees. And when I get my job, I can end up finish paying it off and then just do my AA classes. That's the only class that I have left.
No further questions, Judge.
All right, any objection to the court asking some questions, or State, do you have any questions?
I don't have any other.
No objections, Judge.
Since 2024, when you were placed on this probation, have you ever been employed?
I was working under the table most of the time with painting. And then I ended up, when I got arrested in October, and then when I got out, it was hard for me to find a job, but then I ended up finding a job and I was working about 3-4 months. They let me go. They were letting a lot of people go, but I was working under as a temp for Pacific Seafood. And then from there, I was working with my grandmother. She does events downtown, so I would work every weekend about selling food, setting up the booths, doing that. But while being in here, my mom has a job, and she ended up talking to her supervisors and her team lead, and they said that they have a spot waiting.
All right. And then did you tell probation that you would no longer be able to reside at the listed location?
Yes.
And that was ordered by another judge.
Yes.
When did you tell them you would not be residing at that location?
When I went to one of my probation meetings, I told her that my ex-stepdad and my mom, they ended up splitting up. He kicked us out because he has a new partner. And then I ended up going with my grandma's house, and then Kimberly ended up getting pregnant about 2-3 months while I was there.
All right, why do you say, I don't like when people use the term ended up getting pregnant. Were
Well,
you
no,
not a part of that?
No, yeah, I was. Not my fault.
So, I mean, everybody knows, I'm assuming, how old are you?
Me, I'm 27.
All right, people know how babies are made. So you all
We both
decide or to have a child.
She ended up being pregnant at that time, and my grandma didn't really, because of me getting locked up last year, it was a situation due with her. They didn't really get along too much, so when she had ended up finding that out, she told me I had to leave. So I was staying with her at 6818 Carversenio. I was there for about 2-3 months. Her and her mom ended up getting into it because she had a miscarriage. Then from there, that's when we were staying at hotels and we were just trying to find somewhere to go. And then I asked my grandma if I could stay there again. My uncle ended up moving in. He was just like, I don't want nobody living here because this is gonna be my house pretty soon. And I had nowhere to really go. And then while she found her friend, we stayed at Chase Boulevard. She was letting us stay there. And then right about the ending of September, my sister told me that she ended up getting an apartment. She got another car. She was like, if you do end up not staying there, y'all can come move in with me. And then all this ended up happening.
This is what I don't understand, and maybe you can help me understand it. Why is it that people, they don't have a place to stay? They don't have a stable employment, and they decide they're going to bring a child in the world and they can't even support themselves. And everything that you've told me, and I listened to your answers to the questions, everything that you've told me, you're relying on somebody else. Kimberly has money that she's been saving up since she's been in custody. Somebody else has money, your grandmother, they've been saving up money. And if neither one of them give you that money, we're going to be right back here.
Well, I have that job waiting for me, so I'm willing to work with that. My mom told me they paid from 17, 18 an hour, and I'd be working 3 days a week. So I'd save up all my checks and just pay what I need to pay off myself, take care of my responsibilities.
Any objection to the court reviewing the court summary?
No, Judge.
Any objection? Have you read the court summary?
Yes, Your Honor.
All right, after reading the court summary, probation is basically saying you were never compliant. They said that there was a previous motion to revoke, and this was with a different judge. They say following a motion to revoke filed on October 31st, 2024 for a new offense of assault, his conditions were amended on January 9th. to require weekly reporting indefinitely and residency with his mother. It says, despite these directives, the probationer refused to reside with his mother, citing conflicts, and instead stayed temporarily in a hotel before moving in with his grandmother, failing to provide proof of residence. He has remained unemployed, completed only an aggressive driving course on May 20th, 2025, and otherwise made no progress or required parenting or other classes. He has paid only $38 towards his fees, leaving a delinquency of $1,412. And see, I understand when people can't pay money, but from 2024 to only have paid $38 towards your fees, that's sort of not really trying. And they say his reporting has been inconsistent with frequent failures to appear and intermittent walk-ins, and field visits were often unsuccessful due to his absence. A manager hearing on August 22nd, 2025 documented his continued noncompliance and failure to pay fees, during which he was encouraged to obtain employment. Despite these interventions, he remains noncompliant. Yeah, I don't think probation is for you. I'm going to grant the motion. I'm going to find you guilty, revoke. This will run concurrent with 2025 CR 014998. The court will sentence you to 20 months in the state jail facility, give you credit for any time served. And I'll ask for the therapeutic community. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign?
Yes, Your Honor.
All right, do you have a limited right to appeal? The right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. And I want you to know your attorney did do a great job, and I did listen to everything and internalize everything. But sometimes, you know, you're just not doing well on probation and there's nothing I can do. Okay.
Yes, ma'am.
All right. Good luck to you. Okay.
Thank you.
All right. On moot, yes. Does she has someone on the docket phone? Oh, excuse me. No, that's not what it is. Could you speak with, Ms.
Megan?
Galloway?
I
on
did,
that? Yes.
I did, and I told her that I would speak to him to see what after I explained fully to him what the potential was.
Okay.
He decided that he would like to try and get probation.
Mhm.
So I went ahead and filed a motion for new trial. I had given her a copy of that. I assume she's just going to oppose it. So whenever the court wants to set it, that's
Oh, just said it. I don't know, she may not oppose it. I'll need to see his criminal history. I know he said he only had theft cases. I just
right.
need to see.
I told him that you had not seen the full
Yes,
spectrum yet and that might affect the outcome, but he wanted to try.
okay. And then what I can tell you is if okay, so if they do that, then we'll take care of it.
That'd be great.
Okay.
Yeah, that will work. And whenever the court wants to set it.
Oh, just talk with Miss Ferguson.
Okay.
All right, on Smith.
Judge, unfortunately, he will be ineligible for felony, veterans treatment court.
All right, Norma, on Dominic Smith then. Let's set this, when his attorney comes back, see if 3 weeks is okay with him, when to reset, call this or whatever he wants it set for. All right, is there anyone else ready?
That's the same for Judge too.
Lennon Cortez. Oh, is Charles here? Okay. All right, thank you. Let me see real quick with this and then I'll go to the next one.
The judge will come back tomorrow on all that.
All right, thank you. All right, Charles, you ready?
Yes, Judge.
No problem. All right, the court is calling 2025 CR 0115541 and 2025 CR 0114552, State versus Lennon Cortez. Can I have parties announced?
State.
Charles Blunt for Mr. Cortez.
And are you Mr. Cortez? Counsel, in each of these cause numbers, have you received all discovery and did you review it with your client?
Yes, Judge.
In each cause number, the court will find that the state is in compliance with discovery. Are there any applications?
No, Judge.
And each cause number, Mr. Cortez, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, in each cause number, do you waive the reading of the indictment?
We did.
State in each cause number, are you proceeding on the indictment as presented?
The cause ending in 4-2 state moves to proceed on the lesser included offense of possession of a controlled substance, PG2 less than 1 gram.
No objection.
All right, in each cause numbers, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? In the cause number ending in 4-1, you're charged with unauthorized use of a vehicle. And in cause number ending in 4-2, the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 2, less than 1 gram. Those are state jail felonies. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. Did you understand by entering into these pleas, you're giving up those rights? And did you intend to give up those rights and enter into a plea in each cause number? Counsel, in each cause number, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yeah.
Mr. Cortez, in each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
In each cause number, if you're not a U.S. citizen, by entering into these pleas, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
In each cause number, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Off the record for a moment. So on the plea bargain, I'm sorry, I'm having a bit of trouble understanding the time.
It's 12 months.
41.
Yes.
Okay, so that's 365. It's just that it was, so it's 365 in each.
Yes.
Okay, all right, we're back on the record. In each cause number, according to your plea bargain agreement, punishment is to be assessed at 365 days in the Bexar County Jail under 1244. There's an $800 fine. The cause numbers will run concurrently. And then the cause number ending in 42, state is proceeding on the lesser included offense. Did you understand that to be your plea? Defense?
Yes, Judge.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney in each cause number? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there many such motions?
No, Judge.
Then in 2025 CR 011542, to the lesser included offense of possession of a controlled substance, penalty group 2, less than 1 gram. How do you plead? Guilty, not guilty, or no contest?
No contest.
And cause number 2025 CR 011541, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Judge. Suits exhibit 1 in all.
No objections.
All right, state, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses, the state will call in the right to remain silent. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
And they're the same report in both cases, Judge.
Okay, thank you. I'm just looking for the lab report. Ah, it's labeled. I love when it's labeled. All right, in each cause number, the court will find that there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
We believe he's worthy of the plea bargain. We ask you to follow it.
Odyssey is a little bit slow. And cause number 2025 CR 011541. As previously stated, the court is finding you guilty. Court will sentence you to 365 days in the Bexar County Jail under 1244. Give you credit for any time served. There's an $800 fine. Time and money will run concurrently. And this will run concurrent with 2025 CR 011542. And is this a judgment satisfied or no?
No, Judge.
Is there anything else with regards to sentencing under that clause number?
No, Judge.
Next, we'll proceed in cause number 2025 CR 011544. I'm sorry, that last cause number, court reporter, was that 542?
The last one was 541.
All right, thank you. Then the next cause number we'll proceed in will be 2025 CR 011542. And in that cause number, as previously stated, the court will find you guilty of the lesser included offense of possession of a controlled substance, penalty group 2, less than 1 gram. Court will follow your agreement, sentence you to 365 days in the Bexar County Jail under 1244. Give you credit for any time served. There's an $800 fine. Time and money will run concurrently. And this will run concurrent with 2025 CR 011541. Is there anything else with regards to sentencing under that cause number?
No, Judge.
And each cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because these are plea bargain agreements, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
No.
All right, we can go off the record. Here's the thing. At the jail, I know sometimes people think they're getting 2 for 1 or 3 for 1. I'm not in charge of 2 for 1 or 3 for 1. So if the jail decides not to give you credit of 2 days for every day you spent, you can't come to me for that because I have no jurisdiction over that. The only thing I can tell you is I've sentenced you to 365 days, and that's my sentence. You understand? All right, good luck to you.
Thank you,
Thank you,
Judge.
counsel.
Just have
Good
a
luck.
picture.
Uh, Megan has it.
That should be.
Sure.
And maybe we need to.
Yes,
So I have David Crenshaw done.
yes.
I conferred with the state. They've made a new offer.
Mhm.
I want to see if we can get a reset so I can go through some things with my client. Was sitting right here with the glasses.
All right, just one second.
Yes.
All right, so he's already had his plea deadline date, and I know they've entered a new case, but I need to know something today because his next setting is going to be a jury trial date. Because this was set for a plea deadline date on January 20th.
Yesterday.
Yes. So,
Why don't we go ahead and set it for trial, Judge, with motions to suppress?
okay,
The state's gonna hold that offer open for one more time, but we'll either work it out or we'll.
well, I mean, the court is telling everyone the plea deadline date will have expired.
Right.
So, I mean, if you want to talk to him, you can. Otherwise, it'll be set for trial and we'll go to trial and the court will only consider a plea bargain agreement with good cause. Otherwise, you have to plea open to the court.
That's fine, Judge.
Okay. All right. So on Mr. Crenshaw, how long do y'all expect the trial to last?
4 days at the most.
All right. Oh, sure. Come forward. Hello.
Hello.
Hi. So, we've been in this court, the way I run things is I try to make sure everybody has their discovery. And then I require that the state tender an offer. And then you either accept or reject the offer. And then, there's a plea deadline date for both parties to let the court know whether they've reached an agreement. And if they haven't reached an agreement, then the next setting date will be a jury trial date. And at that time, the court will not consider any plea bargain agreements unless it's for good cause.
So for instance, I've been offered a plea today.
Okay, so here's the thing. I'm not
And
allowed to hear what your agreements
Well,
are.
My question is, if the offer that's being offered today will not be available if I come back?
no, the DA is keeping the offer open till next time. The judge says, if you don't take the offer today, that she may force you to trial. But for good cause. And my argument would be, we would have good cause next time, but that'll be up to the judge.
Yes.
Okay.
Do you understand now?
do it.
Okay. All right. Thank you. All right. So, what's the jury trial date?
And then we could do pre-trial motions right before the trial judge, if it comes to that.
We can do the March 17th.
Okay, March 17th is bad. Brought a list today.
Yeah, I'm glad you brought a list. And then after that, we'll take up the next matter.
April 7th works fine.
All right, your jury trial date is going to be April 7th.
Okay.
And Norm, is that a Tuesday?
Yes.
Put it on Monday just in case they have pre-trial motion.
Crenshaw.
All right, April 6th will be jury trial and motions.
Sounds good. You guys have a great day.
All right, you too.
Yes, sir.
Bye-bye. Thank you.
Did you still need Mr. Dominic?
Yes, because we're trying to get his attorney back so we can get a date to recall that he's not eligible for Veterans Treatment Court. All right, Melissa Paez. Hello. All right, are there applications in these cases?
There are, Your Honor.
Court is calling 2025 CR 008396 and 2025 CR 014167, State versus Melissa Renee Paez. Can I have parties announced for the record?
Trey Mauer for defendant.
All right, and are you Ms. Paez?
Yes.
Counsel, in each cause number, have you received all discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. In each cause number, Ms. Paez, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it?
Yes.
And did you sign it? In each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictments as presented in cause number ending in 9-6?
No, Your Honor, state moves to waive the enhancement allegation as well as count 2 and proceed solely on count 1.
Any objection?
No objections.
And are you proceeding on the indictment as presented in 6-7?
No, Your Honor, state also moves to waive the enhancement allegation in that clause.
Any objection?
No objections.
All right, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
In cause number in 9-6, you're charged with fraudulent possession or use of credit card or debit card, 10 to 50 items as a second-degree felony, range of punishment. I'm sorry, you're only proceeding on one count, correct?
Correct.
Okay, it's just the way it's printed out. We're good though. All right, the range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, sir.
If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. In the cause number ending in 6-7, you're charged with false statement to obtain property or credit, $30,000 to $150,000 as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, sir.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, sir.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Paez, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, sir.
If you're not a U.S. citizen, by entering into these pleas, you will be deported, denied naturalization, or reentry. Did you understand?
Yes, sir.
In each cause number, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. In each cause number, the state is waiving the enhancement. And in cause number ending in in the cause number ending in 9-6, the state is proceeding on count 1. And in each of the cause numbers, the state is asking that your punishment be assessed at 10 years in the prison. There's a $1,200 fine. State is opposed to your application. They're asking that the causes run concurrently. They're taking in consideration 2025 CR 014168, 2025 CR 015020, and 2025 CR 015019. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State? And each cause number, did you review the waiver of appeal paragraph? Did you understand it and sign it in both places?
Yes, sir.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
There are not, Your Honor.
And the cause number ending in 6-7 outside the agreement, there's to be no contact with Mission Mitsubishi at 9800 San Pedro, and there's to be no contact. Did you understand those were recommendations from the state, and the court does not have to follow that recommendation? Then in cause number 2025 CR 008396 to count one, how do you plead?
Guilty.
And in cause number 2025 CR 014167, how do you plead?
Guilty.
State, in each of those cause numbers, do you have any evidence to support the plea?
Yes, Your Honor, state offers states exhibit 1 and all attachments in both causes.
No objections.
All right, state, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, in each cause number, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, the state is opposed to your application. If you would like a PSI and a TAP evaluation, it'll be 8 to 12 weeks. If you would like it brought back sooner, I will listen to whatever witnesses or evidence that's submitted to me and make a decision.
Your Honor, after speaking with my client, we have a request if the court would consider signing the dismissals on the 3 cases that were taken into consideration in light of her plea of guilty and plea onto these 2 cases. If those 3 cases are closed out, and if the court would additionally consider reducing her bond slightly on the 2 that she has pled on, so she could take those full 8 to 12 weeks, organize her witnesses and people that she would like to be here on her behalf, and make sure that she has everything lined up for whatever the court does decide at that point. I believe that's what we are requesting, Your Honor, if the court would consider dismissing those 3 and possibly just slightly reducing the bonds on the 2 that she's pled on so she can organize everything and take the full time for the PSI.
All right, so with regards to bond reductions, you'll have to file a motion and then I'll hear it so that the state can be prepared.
Okay.
And if the state is waiving notice, just whenever you all get together, the court will do that. Now, with regards to the dismissals, any objections to the court signing the dismissals now, or?
Object, Your Honor, because that is something that ensures or will be dealt with at the resolution depending on what this court does.
And maybe I should have discussed this with you beforehand. If I may say, Your Honor, I've understood previously that if someone enters a plea and then does not return, that, that plea can be, the court can say we're not going to accept the plea and that the full range is open. I believe that on its own will be sufficient to guarantee that she'll be here, and she'll, accept whatever the court decides at that point.
All right, so this is what I can tell you all. This is new to me. With regards to the court signing the dismissals, the signing of dismissals to the court appears to be a part of your plea bargain agreement. And until the plea bargain agreement is accepted by the court, which it hasn't been accepted, right? The only thing that I'm doing is memorializing for the record that this is your plea bargain agreement. I have not accepted it yet. However, again, it's novel to me. If somebody brings me some case law that says that the court can make a decision with its own discretion to dismiss cases if a plea bargain agreement has been entered to but not accepted by the court, I'll consider it. But my understanding of the law is that unless the state says they're in agreement to these cases being dismissed now, they're really not to be dismissed now. Because your plea bargain agreement, I haven't even accepted it yet and entered a sentence. I've just accepted the contract that you want to enter into. Do you understand? All right. So, but again, if somebody brings me case law that says something differently, I'll review it. I never said I know everything.
We take a quick step back just so I can discuss with my client very briefly, Your Honor.
Sure. And then let me know if you all want the 12 weeks or not, 8 to
Okay.
12 weeks or not.
Thank you, Judge.
Sure. All right, Norma. The attorney hasn't come back, but I know he said that he did not want the PSI on Mr. Smith. When do you want that brought back?
He said he's on his way back.
Ah, okay. And usually this is what I've discovered. When we have a docket that is not as full, we still end up being here for a long time. But I like to make sure that I hear everything. And this is what I tell people about judges. Well, about me. I don't claim to know everything. I don't know every law under the sun. But if somebody brings me some law that says, Judge, you're incorrect, I'll listen to it and change it. Or if it's something that's novel, like that is novel, that's the first time that's been brought. But if he brings me case law and says, oh, no, Judge, it's within your discretion, then I'll hear it. Yes.
Your Honor, my client has decided to do not the full PSI. Will come back sooner rather than later.
All right, so let's go. We're back on the record. If you'll come forward. All right, so are you asking that the PSI be waived? All right. And then with regards to TAP evaluation, are you asking that that be waived as well?
Is it going to be the same wait time, Your Honor?
Vashon, how long is TAP just for a TAP evaluation? TAP evaluation is 4 weeks.
We'll do the TAP evaluation, Your Honor.
All right, so there is a request for a TAP evaluation. It's in both cause numbers. It's 2025 CR 014167 and 2025 CR 008396. All right, Ms. Ferguson, what date? Yes, and Ms. Abrams, if they can expedite that and maybe get it to us sooner than 4 weeks, we'll try.
I can do February 25th. Oh, I'm sorry, the 26th, Judge.
February 26th. And if for some reason, if they're able to do it sooner, they'll let your attorney know.
Yeah.
All right, you're welcome. Is there anything else?
Nothing to prevent.
All right, with that, we'll close the record.
Thank you, Your Honor.
And with regards to that, is there any restitution that's being alleged? Okay, all right, thank you. Okay, well, I will see you all on Thursday. We're just waiting, state if you can remain because we're just